So we're talking about the case. And like I said, unless you've been under a rock, you definitely know what is going on. It's all over social media. You and I have been following this long before everyone else started talking about it, back in when they were just doing depositions. Then it went to trial. And now the trial is over. The defendants were found liable of an antitrust violation, and the jury awarded $1.7 billion in damages, which automatically trebled to $5.35 billion. And here we are. Everyone is putting out their opinion. Who's saying, we're going to fight this, we're going to appeal. And I want to talk to you about that because, can they appeal? What does that look like?
Well, first, let's say what happened. The cornerstone, this is a class action. And the allegations were that there was a real serious conspiracy for users of the National Association of Realtors and the other defendants, which created a conspiracy which elevated prices for sellers based on the cornerstone of the Board of Realtors, which is the clear cooperation policy. Under that policy, sellers paid their listing agents a certain sum, and then some of that amount was offered to cooperating agents, usually on behalf of the buyer. Well, that was found to be violative of the Sherman Act, 1938 antitrust federal law, because it said that it created too much money for sellers to pay, and that artificially inflated prices, and it was restraint of trade as well on a few different matters. We'll get into the standards used, but the allegations were that it started with consumer protection, where they thought that one party, based on a few complaints by a few individuals, and this started in 2019, thought they paid too much, and it was looked at, and the Department of Justice got involved and said that, listen, we have some really strict standards by which a restraint of trade is measured. Some of those we'll go into. Some are really demonstrating how unequal some of the efforts that were made by each of the respective fiduciaries for each client, and technology had a disruption, but the Department of Justice felt like it was not enough.
Mm-hmm. Yeah. So, what really took place is they were found liable for the antitrust violation. And that's really what it's about, where agents are going out on social media and they're talking about, well, we work really hard, we deserve this, the seller pays. None of that is relevant at this point, because we're talking antitrust. They were found liable. There is a number of $1.7 billion in damages. And like I said before, it trebled to $5.35 billion in damages. And if you talk to anyone in our industry, they're saying, well, NAR is going to appeal this. We're going to fight. We're going to do this over again. We're going to win this time. And that can't happen, I think. I think it can.
There are some articles describing what constitutes the opportunity for an appeal. An appeal here first has to come after a decision. We're waiting for the decision. And that could be in the next.
Well, how long do we have for the decision? It's like 30 days, right?
No, it has to be a decision, and we're not the court. They say when they make a decision. So they're going to make
a decision they
want, and it's going to be a great one because they're not fooling around. And then 30-day clock starts, and a few things have to happen generally. There needs to be a hearing where even an appeal could be granted. That is to demonstrate several grounds. There has to be a bonding, which bonding companies are called surety companies, have to approve this even opportunity. They have to say, yes, we want to take that bond. There are very few that can. The requirement is to have either that much collateral of $5.4 billion. Right.
So they're looking for 100% collateral typically.
And that could, typically it could be reduced upon showing upon need. Some scholars have said that they don't have that much. There's not enough to bond. There's not enough money for them to put up. So basically, it's just like some kind of a de facto stay. They could pay the money, but they want to show that it's not valid. They have bases to have the appellate court, determine that the lower court aired as a matter of law. So
that would be on the appeal. So they would have to say that that happened in order to grant the appeal.
right, and this is, I mean, it's not a fact base. It's not. They're not remanding the trial. They're not remanding the case to be tried again. There was actually an attempt by the defendants to have some video excluded. It was never entered into evidence, and they attempted, even filed a motion for a mistrial, and that was denied. So it's important to know that this judge denied the defendant's motion to dismiss, denied the motion in opposition to the class action, and denied the motion for mistrial. So the court has not been sympathetic. We'll talk about the standards they use too. Naturally, people have views towards this clear cooperation policy. It has been seen as a really beneficial aspect of the home buying purpose, because people got representation where they otherwise could not have. So they got a real nice benefit, and there was a sense of fairness surrounding these transactions. People who, kind of like a personal injury action, you can't afford a lawyer, so you get to be a class action. However, this is the reverse. Representation is a great thing, to me, if you can afford it. And there was no opportunity for the market to show that there was a need or a desire to pay that much for buyers to pay that much, or actually cause the sellers to pay that much. The sellers are never going to given a chance.
And if they even realized who was really paying, because if you go out into our industry, who's paying, some will tell you the seller's paying it because it's in the contract of the seller between the listing agent and the seller. And then others will say it's the buyer really paying it because the buyer, it's incorporated into the price of the house that the buyer is paying. And then they're also financing that. So it's not even X amount, it's X amount plus, 30 years possibly, amortized.
Finance over time. I'm looking for an article now. That was, to me, that was a really low level issue. I always thought a bit myself, where the buyers, of course, fund the transaction and they finance some percentage of the loan of value. And the seller signs a contract, so it's seen as they paid. It's really, I don't even think it's what I would call a nuance. I think it's just a contradiction in terms. And I think that's also risen to the level of a legal fiction, where someone's paying when someone's funding.
Legal fiction, I like that.
Legal fiction, where everyone kind of agrees, that the emperor's really wearing clothes, and he's not. He's not. So that's the way that people will still get argument on that. So sellers were paying an amount to buyers for buyers representation, which is really unique, because other than in a demonstration of need in a divorce, one party's representation is not paid by the contractual counterpart, potentially adversary. So that's fraught with danger of what could happen with some confidential communication. The realtors speak on behalf of the clients, but you don't know what could come out at deposition. Then the allegation would have to be that's privileged. And to the extent of that, I don't know. I mean, they're not lawyers, they're not priests, they're not psychologists, where there's the classic attorney-client privilege of communication. Where, I mean, does a realtor have that? Does a person speaking to a realtor have that? I don't know. I mean, just because they're fiduciary doesn't mean they have privileged communication. This is, not for everyone to know. So, let's just realize that the clear cooperation policy was found to be violative of the Sherman Antitrust Act, where it restrained trade. I mean, it really did. There's so many parts of this, and because there's such an on its face prima facie allegation, or even a demonstration that these practices were in place. By these practices, I mean paying for the other side's, the buyer's representation. It became,
and let's just pull that back a little bit, because what we're saying, what happened here was that the listing agent goes out, takes a listing, and puts into the contract X amount, and then says, I'm going to offer this amount to the buyer agent, who's not even a part of this contract. So that buyer agent now finally appears, brings forward a buyer, and now they are working under the listing agent's contract. And that's where the problem really comes to play, that the buyer never really had any say in how much they were paying their buyer agent.
I mean, they were gifted in some sense. They were relieved of the obligation to bring money to the closing, but they also were stigmatized in that they were not aware of the amount based on the loan to value. It was baked in, as is stated. They didn't know what that amount was going to cost them over
And
time.
if a buyer is unaware, how can they possibly negotiate this?
And because they weren't able to negotiate, this commission was never exposed to the market. Someone could have rejected. Some could have said, "Wow, I love this. Let's pay more." But the seller bore the brunt of that expense. Let me just read some notes or some cool stuff.
Okay.
This was the case was filed. This is the first of several or many, and there's another one coming.
There's a few coming, not just one.
The Department of Justice has its own issues. So keep in mind, this started in 2019. This case alleging that. Let me show you. Shoot. I had it perfectly. Okay, let's just go over some things. It was 250 home sellers in Missouri. That's what this alleges. And the allegation is that these entities conspired to artificially inflate the home sale commission paid to real estate agent. And because it's 1.8 billion, treble damages based on that allegation was 3 times that amount. Treble, I guess it means
treble is 3 times.
Lawyers say triple like treble. So really NAR's commission policy was on trial. And the cornerstone of this conspiracy, they say, is requiring for home sellers to pay commissions to the agent representing the buyer. And only this happened because the boards of realtors and the NAR required an offer of compensation to use the MLS. The MLS is, as you know, a cool spot where properties are listed. But to get on there, you have to be a member of the board and you have to follow those rules. So they're saying the vast majority of the homes are sold on MLS. The plaintiffs claim home sellers are forced to pay a cost that should be paid for the buyer, which, to be honest with you, I always thought. It kind of shocked my conscience, and one party paid for the other. So the allegation is that this conspiracy caused sellers to pay more for brokerage service when selling the homes they would have paid absent the conspiracy. And NAR, and you're a member of NAR, and I'm a member of NAR. They've done their biggest lobbyists. They've done a lot for the country and people. They say that they say it's not the case. They are appealing, and what I think they're not telling the public is that they get a very, very limited appeal. And that is the allegation is that the court erred as a matter of law, and they're not stating the standard by which it's used. It's the standard per se, which simply is, did it happen? And if it did,
yes or no, right?
Yes or
not
no.
Why it happens, not how we felt about it, but did it happen? Yes or no.
Or any factors around it. So what you hear even after the fact, ex post facto, is that the buyer representation is really a good idea. It helps people that would not have access to these transactions. There are so many things. I mean, the property condition, their rights and obligations. Realtors do a lot of work, and it's great work. We've both done it. It's not a question of how valuable it is, which I know appeals to people's sense of fairness. It's did it happen? So it was really, let's use some Latin, flawed ab initio from the beginning. It was a fatal flaw, which at one point some people before 2019 said, let's do something about this. They want their money back. Now, I mean, that's what happened. And then, of course, let's get to some settlements. Remax and Realogy settled. And they said, one is 55 million, one is 83 million.
One is 83
million. Deal. If you're sued for 1.87 billion, we got off less, but that settlement was supposed to be approved in January. It's getting approved in March 2024. And the DOJ doesn't like it if they thought that there is not enough teeth in that. They said, we appreciate your idea that we're going to change the disclosure, but we want more. So keep in mind that
they were changing the requirements of offering the buyer agency compensation.
Right.
And then they were also they were changing the requirement of actually mandating that their agents would have to join NAR.
Right. But important to remember is, against the backdrop of the plaintiffs, they sought injunctive relief. Means they want this to stop. So the DOJ says
they want to change the system. They don't want anyone doing
they're
business the way we've done it.
Right. They're not. I mean, they're going to change by virtue of elimination. They're not going to change it. They don't want it to be this thing. They want it to be gone because they think it's violative. And the jury agreed. and now we're just waiting for the judge's decision, which really is going to have an impact. So, and I kind of
the sad part about all of this is that I think you and I understand this. I think a lot of people understand what took place in the court. What we're not understanding is this appeal process, because too many people out there are saying, oh, this will be years before there will be any changes. We're going to appeal this. We're going to win this. I don't know if that's going to happen.
I mean, listen, it's Rob Hahn, a friend, a really brilliant lawyer, put it out there today, and we spoke about it. It's a really, really arduous process. It's one that he says can't be met, where it has, they have to be granted the right to appeal based on really some need that has to be demonstrated. They have to have enough money to bond it. They have to have some real credible issues of fact. And I think that because the court took such a
very hard
conservative approach with this, could use the per se standard. I'm no legal scholar. I was admitted to the bar in New York, Connecticut federal bar in 1992. But I mean, I've really been paying attention to this thing. What's really important is that when these plaintiffs sought injunctive relief, they wanted to stop. So when these two companies come out and say, oh, we'll give a disclosure, that's a million miles from stopping. And I always said, what, and then some of the people on social media were saying, well, we got off with 55 million, not 1.87 billion. I said, well, it's not your money. Why do you care? As long as you're in business. And people thought it was about money. It really is not about money. It's about business, about changing or altering or eliminating this practice. So we don't know. It could be that this thing becomes moot when the judge's decision. The court could just say it's done. We get the injunctive relief that was sought is granted. Then what? Then I mean, there's an appeal based on, and it's only 30 days. So it's not a ton of time. This case took 4.5 years, and the jury took 160 minutes to change American real estate. So, I mean, this is, 8 people. I love to sell when we speak to the lenders and vendors. I say,
8 people changed the industry.
8 people answered 4 questions, and all of those 4 were yes. So in a normal case, the judge charges the jury. They don't have a choice like it's TV. They say, if you find 1, 2, 3, 4, you must. Now you must vote in the favor of the plaintiffs. If you vote yes, no, yes, maybe you don't. But if all your yeses, that's the only verdict he's going to accept or she's going to accept. So when you think about how bad were the practices of these organizations, that it took a jury
160 minutes.
160 minutes. And I mean, NAR and the others at all.
Not even 160 minutes. Wasn't it like an hour?
2 hours, 240, 150, I don't know. But I mean, they all had their day in court. They all had briefs upon briefs. They all hired, I mean, think of the lawyers that NAR has at its disposal. Limitless money. It's got to be a best law firm.
Yeah. I mean, NAR said they made something like $225 million just last year alone. So, I mean, this is an organization that can definitely hire the best of the best.
Right. But, those lawyers are handcuffed by the facts. The facts in this case, we're not talking about the other extraneous matters of how important representation is. It's just, did it happen? Did this stuff happen?
And they were talking about price fixing. They were saying, was there price fixing or was there not? Yes or no?
And some of the indicia were, that's a good point you make. Commission rates were not 20, they were not 16, they were not 9, they were not 1, they were not 2. They call it clumping. They were always 3, they were not 3. There were these even numbers of 4 and 6, 3 and 3, 2 and 2, logically to the brain. So that we call clumping. That's an indicia because we're all agreeing. Victoria can't charge 26. Scott can't charge 1.5. So the allegation was there was clumping. 1, 2. They did not like that top pros got paid the same as brand new rookies because the market, if you had a chance for the best doctor, you might want the best doctor and you might pay for the best doctor.
And you might pay a little bit more.
Or a lot more if they had some health ethics, right? So, so the buyers and sellers were stuck in paying the same amount to someone, A, who's not competent, and B, is working against them with a lower offer. So they're paid the same. That's another piece of it. It's another indicia. And lastly, which was a kind of cool one, is that technology did not upseat anyone. So Zillow comes in, and that you would think because a big part of the realtor's former role was finding a property. Hey, anything to sell?
They used to
Victoria?
be the gatekeepers of the information,
Right,
and
and
now
now they're
they're
not.
no longer the
Now the
gatekeeper.
opposite. So when
Mhm.
the court
And
took
nothing changed.
and nothing changed. So instead of realtors saying, I have this property, people call it says, I like this property. So the flipped roles of a home finder and a home, retriever. So when technology doesn't have a serious erosion, like stockbrokers, like
Mhm.
hotels, like airfare, like
Right,
Expedia,
travel, right.
all those things, you now look on your phone and you know what Southwest is going to cost you to go from Albuquerque to San Fran in Christmas. I mean, you don't need to ask anybody. So
Right.
those are really the three big reasons. And again, I am not anyone's lawyer. I'm not practicing, but this is what happened. So now we know. I mean, to all our realtors and all our vendor partners, everyone has to change how they do business. And in some states,
Before we go there, I understand that, and I know you understand that, but the problem that I'm seeing is going on social media, and I know you've been having a field day on social media with this because you're asking a lot of the right questions. Why do you think that? The agents are out there really believing, and I'm not thinking that they're just putting it out there to put it out there. I think they really do believe that this is going to get appealed, that this is going to be years, and that they can continue to operate the same way that they have been operating in the past, and nothing is really going to change. But that's really not the case.
yeah, of course, but you got to realize there's 1.5 million realtors serving 50 states. There's 600,000 lawyers, and I don't think there's 6,000, 1% that is involved in this. It's got to be closer to 600 in America. This is the highly specialized. Here's me, didn't know about this 3 months ago. Now it became some, kind of someone making comments. Some of the amazing people have been on this, so it's they can't. And plus, I tell you, NAR, whether you say it's responsibly or irresponsibly, is saying they'll appeal and they'll win. I mean, that's
Right.
my trade
And I
organization.
think they want to, but I mean, it doesn't really look good for NAR, whether they were granted an appeal or not. Because if they do an appeal, let's say they knock this down and they have to come in with a lesser amount, they still have to get bonded. So what would they do? And I'm going to read you some numbers. And I pulled it from an article that you sent me, and I thought it was so well done because this is public information. Anyone can look this up. So according to NAR's tax filings, and last filings that we have that we can find are from 2021, and NAR has $1 billion in total assets, but only 112 million in cash. So now let's look at the two defendants that were there. All right, one was Keller Williams, right? So as per the 2023 franchise disclosure documents that were publicly filed, and we all know these franchise disclosures are filed with the Attorney General, and they have to be filed in every state. So, and every year they have to do this, right? So these are real numbers.
And the
And
SEC,
it's
these are
public knowledge.
publicly traded. What about the SEC? SEC knows about it. They're publicly traded.
Right. Well, I'm not up to that. Keller Williams is not publicly traded. I'm talking about Keller Williams with the franchise disclosure, and what they filed in 2023 was that they have 331 million in total assets, but only 47 million in cash. And now you go to BHHS, which is a subsidiary of actually a subsidiary of a subsidiary of Berkshire Hathaway, and they show less. So I mean, they're up there. They're right around the same number, somewhere around that 50 million number with Keller Williams. So if you take all of those three, there's not enough money if you're talking about having to have full collateral, even if they got it down to 300 million. Now, let's say NAR says, you know what, we have the most assets. We're going to liquidate everything. We're going to sell everything off. We're going to stand behind this. We're going to fight. We're going to get this appeal, and we're going to get this bonded by putting every single penny we have into this. Are they really going to do that? Because there's three
No,
other
they're not going to do
that are
that.
coming.
And I just don't know. There's another side to it. I thought, why does it NAR? I mean, before I say that, I want to say I think publicly that it's very irresponsible for the president of the organization to say they're going to appeal and win. Neither one is known. And of course, a president or even NAR leadership, they know their lawyers. the lawyers who tried the case are surely available and knowledgeable about the next possible step. They're not going to think, hey, who knew that? They know, even if they're not the appellate firm, that might be, they know everything more than anyone. They're the losing party. They know what might be, so they don't communicate that to their client, and the client doesn't learn. So the client has the attorneys, has the access, had to be briefed before this happened, win or lose. So they're just saying to their public, the members, we're okay. I mean, how is that not irresponsible?
Well, that's what I'm saying. You know, like, I think they want to fight this. I think they want to do this, and they want to appeal it. I don't see how they would be able to.
Right, but that's your amateur analysis. I want to be 6'2", no chance. So, no chance.
Let's say, you know, they do this because they're afraid that if they don't do it, then Keller Williams and BHHS will then be forced to settle. And that if they settle, what does that mean? That means that they join forces with Anywhere and Remax, right? The two that, you know, made the offer to settle, and said that part of that settlement was that their agents would no longer be required to join NAR. If they're no longer required to join NAR, they no longer have to be in compliance with the code of ethics. What will that do? Now you're talking about how many real estate companies with how many agents out there not joining NAR, not following the rules, not doing what was in place before.
No code of ethics.
Yay, it's a losing situation for NAR, I think.
Well, I mean, I thought about this. Why doesn't NAR just, you know, take, I don't want to even call it a loss, just take this change and say, okay, we're here for those people that want to be members. You can have a code of ethics. Business is done this way. They may negotiate and settle universally, so they don't have, you know, such an overbearing amount. Why don't they, I mean, just see if they could get away with way less money, which I kind of think would happen if the Department of Justice thought it might. I mean, the Department of Justice doesn't care about the money, as far as I can know. They care about this violent conduct of the Sherman Act. So if they get their way, if everyone just lays down their arms and say, okay, you're right, let's do it this way. I mean, is it that crazy for agents to be like a house painter or a dentist or an accountant where they tell you what they do for their compensation? Does there have to be this, hate to say it, secrecy? Does it have to be? Well, you know, that's an issue. And, you know, there's that opportunity. And I think back to the leadership of NAR, I think they should have just said, listen, we will. And all they could do is explore the opportunity to conduct hearings, whether we get a hearing for appeal. There's something called writ. I
agree. And at that point, they would be setting everyone up for the proper changes that will most likely be coming down.
Or even if not, I mean, they should center their efforts on having an appeal step by step. There's no guarantee that the court is going to issue a writ, which means, yes, we'll hear your case if you get a bond. And this is 30 days. So who can bond it? Do they have the money to bond it? I mean, again, Rob Hahn's interview and videos is classic, has all the information. But I mean, for members of the NAR to be misled to the extent they're piping off publicly in front of their clients, logging video. I mean, do they ultimately want to have months and months and months of egg on their face? Because I have friends and clients that, what is this about? And the guy's, you know, an investor. I said, oh, listen, just hold on to your hat because we don't have a decision yet. I mean, it might be just done immediately. But I want to read just some of the.
Everyone's talking about it. Yeah, go ahead and read that. And then I want to talk to you about Rebney when you're done with
we're going. That's a good point. So, I mean, so this guy, Ketchmark, he's, of course, you know,
Ketchmark is the attorney for the plaintiff.
Ketchmark's the plaintiff's attorney. And they earned over $550 million out of this 1.7. They became 5.4. They agreed because the people wonder why they got paid so much. Here's why. This allegation is a tort. A tort is a civil wrong. If it's like a personal injury, except nobody got hurt.
They are personal injury attorneys originally, right?
And Mr. Sitzer and Mr. Burnett and the other people, the new one is there's Notisac. There's another one called this guy Gibson. Gibson is the new plaintiff. He's the new guy. These are people. They go to Starbucks. They go to school night. they may even take in a ball game or movie. So
Mhm.
they are people, and they felt aggrieved. And because they hit the high note of something as serious as the antitrust, the Department of Justice, and they're still looking at it. So Ketchmark is, people wonder why he's getting paid that much, and that's because they agreed. It could be that these plaintiffs, just like someone who slips and falls at the supermarket, had no money or not enough money to fund a lawsuit of this nature since before 2019. They had the money to pay
Mhm.
this law firm of all law firms, so they said, "We'll take it on a contingency basis." And that's why a lot of social media commentaries, why do they get to be paid? Well, first of all, it's a really easy one. Their clients agreed to it.
Mhm.
No clients here agreed to this. So that's the essence. It's kind of
Really good point right there.
right. And
Really good point.
so that's it. But there's a new case called Gibson, and I'm going to
And
show
by
you.
the way, I have to say, I mean, I hate that this is happening. I mean, I've been in real estate for 30 something years, and I hate that this is happening, but the reality is it's happening. And we need to prepare, and we need to understand why it happened and where we are right now. So go ahead.
And understand that, what happened. That was just Halloween, which is a minute ago. We still have candy in
Yeah.
the house. I mean, it's not long ago, right? There's still pumpkins in front of the house. So this is a minute ago, respectively. So the aftermath is even, it's an onslaught. So listen to what Mr. Ketchmark says. So Gibson is the new guy, and they're suing again National Association of Realtors. So they're just getting hit and hit and hit.
Mhm.
They seek damages of 200 billion. The former
200 billion
B
with a
like
B. 200 billion.
right.
Mhm.
And the other one, the first one, sought 13.1. Okay, and they made the claim for 178, which is true.
1.78. Mhm.
So now 200 million could be 600 billion as a result of traveling. Sounds crazy. Sounds like Star Trek, right? And Ketchmark says, we're in alignment with what the Department of Justice wants to make real estate part of the quote unquote free market to get out of NAR, out of the bad in the word rigging system. We think it's real opportunity. Ketchmark said the conversations with DOJ and think tanks have centered around putting the trade organization, in his words, out of the business of using MLS as a vehicle for higher commissions. His words, not mine.
Mhm.
He writes, this is one of the rare things in our country, regardless of policy, people can come together. Everyone agrees we have to get the National Association of Realtors out of the pockets of homeowners. It is not right, and the jury exposed it for what it was. This is from Inman News. I'm a subscriber. This is just
Mhm.
like the New York Times. I can read right
Right.
from it. This is a new,
No, I'm glad you're reading this because these are the facts.
and
And
these are all against brand names. We've all heard of. I mean, has anyone ever heard of Century 21, Coldwell Banker, Remax, Berkshire Hathaway, EXP, Compass, Weicker? We've all heard of Howard Hanna, Douglas Elliman. So Compass, it's here,
it's here.
and
And it's not going away. And we can put our head in the sand all we want. We have a problem.
now, I mean, you're a pro. What percentage of realtors are listing agents, would you say, in any market?
I would say it's less than half.
Okay, people say that, right? So
Mhm.
now, what happened was, and I wonder, the other half, if there is no offer of compensation, which is now, I mean, going to be the case, and I think the prudent approach is to do that, where you'll be continuing to be acting violative of the act. If half of if a buyer is looking for a property and their realtor they select is not getting paid or no compensation is offered from the seller, they have the choice to go directly to listing agent or hire a realtor. And
Mhm.
what does the realtor say at that point?
You owe me money. I need you to sign a contract.
Mm-hmm. Of what amount?
If you want me to do that, you want me to show this house to you, you and I have to have a contract because the seller is not paying. If that's the situation
Mm-hmm.
that you just described.
And wouldn't that realtor, I think, would try to match what was prior or otherwise offered on the MLS?
Well, they absolutely would try. I don't know if that will happen anymore because I think the public would fight over $20. So, of course, they're going to say, well, why would I have to pay X amount? And think about this. If you're talking about a 3% or 2.5%, how many people are first-time home buyers and going through an FHA loan and they're putting 3.5% down? That's their entire down payment. Are they really going to come in with double that so that they can pay an agent, or are they going to try to negotiate down to the best that they possibly can? I think they're going to try to negotiate or cut the agent out. So the agent has to really be prepared, understand, demonstrate true value of why they deserve what they deserve. And will we see the numbers that we saw before? Probably not.
Okay, so using your example, let's say a broker has 50 agents and 20 are good enough to even get paid. Then the question, the amount is still we don't know. So what about the 30 that don't have any experience, or none of them experience? They haven't experienced training. What if they just
They'll
deal
leave
with
the business.
What if they just do a bad job and let people know while we're in the driveway, oh, you got to sign this, and the buyers of 20/20 vision, they see the listing agent's phone number right behind.
Yeah.
I mean, we're talking about a broker owner.
What's to stop them? Yeah. What's to stop them from saying, no, I'm not signing anything and I'm going to call Scott, the listing agent?
Right. And think about how easy it was. Think about the accounting before. If there was an average of, let's say, $300,000 and there was 20 deals, they knew that the commission commensurate with that. I don't know what the commission is. I don't want to speak about commissions, but if it was X dollars.
No, we don't want to do that.
Whatever it is, it's just simply X dollars or
Right.
X percent against the average of 300,000. The broker knows every deal is coming with money. Now it's going to be all over the place. You know, all over. Who knows if Victoria is the best negotiator and Scott stinks. He's never even been trained. He says, use me because I'm your neighbor. And I need a big dollar. They may not. So, and then, you know, when you and I talked about what I call the curb conversation. If we live in a world where Zillow connects buyers with agents, and that really, I thought about how that severely contradicts the approach of having buyer consultation. So now you're
absolutely, it changed the way everyone did business because Zillow taught agents close for the appointment as quick as possible. You know, and in the past it was a relationship business, and it was now turned into a transactional business, which is exactly where this is going, even more so. This is going in the direction of being transactional.
Zillow was 2006, and this disruptor came in, this innovator, this national icon. The commercials show that a couple or an individual is looking on their iPad at 11 o'clock at night with the fuzzy slippers. So now you have the power in your hands. So this disruptor put the property in people's hands, and they also now did to homes or to realtors. They made them a commodity, just like a hotel room, just like a seat on a plane, just like even Airbnb. So that they took the realtor services and basically
they diluted it. Yeah.
And I mean, if a realtor is part of that Zillow system where it pays for the area code, where's the chance to conduct a real buyer consultation? You are a fiduciary. Don't you want them to know what they're in for, or what risks they run, or the opportunities they have?
Okay, so even the agent that has the ability to say, you know, okay, I'm going to close to the appointment, but before we have that appointment, I'm going to have a conversation with you before I meet you, and we are going to have our buyer consultation. You know, there's a lot of different training that has to go into effect here because everything has changed, everything. And now, you know, who knows what a buyer is willing to pay? You know, it's all over the news. You know, who knows what they're willing to pay? And who knows the ability of the buyer agent? I do think a lot of agents will leave the business because of this. I do think that there will be some who will rise and do very well in this, but as a buyer agent, I think it's going to be a lot more difficult.
Well, look at the parties to the contract. You have a listing presentation, you demonstrate your value, you're calm, you're at an office or their home. You obviously take the time, you can create a relationship, versus a buyer where it's a race and people would jump over the ottoman to get to the phone in like your mom's house back in the day, and you are rushing and there's no time. I mean, if you don't get the call, someone else. I've seen people at graduations grabbing a Zillow call. I mean, so.
Oh, yeah. I had agents fighting with their phone companies because the tower was too slow and they got the call just, you know, a half of a second too late. You know, so they were chasing this. They were definitely chasing the leads.
So, another fiduciary, of course, is a lawyer. That's an easy one. But the executor or executrix of an estate, they can't act like this. They don't run to their house and sign this. It's a real process. So the realtors, I mean, by some people say feeding the Zillow beast, but even if they don't, even if you have done well with Zillow, you definitely are compromising your fiduciary standards. So there's that. So, I mean, if you don't have that opportunity, to speak, how can you ever say it's a good idea to pay me? Right? And then I call the curb conversation when you get to the property and there's been no buyer consultation, the buyer's agent, and you're kind of horse trading. Can you pay me 2%? I mean, 1%, 19%, 85%.
And you pay me $300 because I know you see the sign behind me. You don't even have to see the sign. Everything's online. All you have to do is put in the address on your phone.
But keep in mind that no agent has the right to make a deal. That means the broker has to sign off on any contract that might exist, the buyer agency agreement. That means there's 20 agents using a number, and there's hometown real estate on the corner. That means that broker owner would be on standby all day to say, yes, Sally, you can do X. Yes, Mary, you can do Y. Versus before.
Well, I have another question for you, though. Let's think about this. Let's say everything goes smooth. Yes, I'm willing to pay. I sign an agreement. We get to closing. I didn't realize it was that much. I'm sorry, I'm not paying you. This is a very different situation now because the buyer contract and the buyer is between the buyer agent and the buyer. Has nothing to do with the listing agent's contract.
Now it was before. I mean,
it was before because the buyer agent compensation was a part of the listing agreement. Now it may not be a part of the agreement.
Right. Plus, in those cases, because there was a policy and there's all kinds of rules in the board, it was never the case that one real estate company did not pay the other one. That never, ever happened.
Never happened.
Because they know the rules and they don't want a problem. And it's just the right way it works. It's the appropriate professional approach. Now you're dealing with individuals. And even if they get to the closing, I don't know how good a job the realtor is going to do making sure, if you owe me, here's my invoice. If they don't come, that doesn't stop the closing. Now you have a simple breach of contract action. And that means that if you get to court after discovery, after motion practice, after people are paying lawyers.
And what's the cost of all of that?
Exactly. And I saw a ridiculous comment by someone on social media. They said, well, we want to cooperate because the courts want not to flood the docket. So we're supposed to believe that the judicial system is concerned about too many cases of breach of contract actions everywhere. You can't. Opinions are like everything else. Everyone has their own. So
there's a lot of opinions right now. So I want to talk about REBNY because REBNY is the Real Estate Board of New York.
Right.
And the Real Estate Board of New York was never a part of the National Association of Realtors. So the agents that were licensed in New York State that worked in Manhattan primarily.
Or the 5 boroughs, all 5 boroughs, your hometown.
The other 5 boroughs, but most of the boroughs were also a part of NAR. They are headquartered in New York City, in Manhattan, and they can go outside of that, of course, but if you're a member of REBNY, chances are you're not a realtor. I mean, you might have both affiliations, but if you have a listing under REBNY is saying not only are they removing the opportunity to the requirement rather of putting buyer agency compensation, and they're saying you absolutely cannot. And if you do, under our association, you are in violation. Right.
So the reasoning for REBNY said, and they did this immediately. They did this like the day
immediately, the next day.
The next day. So they've been watching this, and they're no fools, and they're dealing with Manhattan values. Think about where New York City
multi-millions.
It's beyond comprehension. Any of the main thoroughfares. Okay, so they said that we're going to give you a real clunky, borderline hostile process because there is no more a right for sellers to authorize a listing agent to offer compensation. That just can't happen. So their reasoning was, we want to get ahead of where we know this is going. So they took affirmative steps and they just altered And think about it, they didn't even kind of advocate for the members that may want to, to do this. So Element and Corcoran, I don't know about Corcoran actually, but Element is a so any Element
Corcoran is under Anywhere.
Anyway, okay, so both, or let's just say two big companies in New York County, it's Manhattan, New York, both said without even hesitation, our members will not offer and our other members will not seek compensation from the other party.
Mm-hmm.
And they said, here's the only way it's going to happen as far as New Year's Day.
Right. So anything that's existing today stays the same, but as of January 1st, if you offer buyer compensation from the seller to the buyer, you are in violation.
It's in violation. They say illegal. I don't know. It's not against the penal code. I don't know what that really means, but it's something that, they can enforce.
Yeah.
Okay.
Illegal under their roof.
They say this is the manner which is going to be done. I say clunky. I say kind of crazy. We're going to show the problems. The rule now stands that if a buyer wants representation, and then you can judge for yourself how much that's going to happen, they can then ask their buyer's agent, the prospective buyer's agent, if it happens, to reach the listing agent and then ask the listing agent if they can reach the seller, because there's, these private communications, if the seller will pay for their representation. And if all of it is if it's properly conveyed and it's all a yes, then the seller, not within the deal, I guess the sellers could use it, from the down payment or escrow money, can pay the buyer's agent. So it would no longer be seller, realtor, or seller, licensee. It would be seller to the buyer's agent, skipping the listing agent. Think of the seismic shift, the sea change. You are skipping the agent, which was the cornerstone of this whole, what I call legal fiction. It was made up.
And what are the chances that would take place? I mean, yes, it would probably be.
I think none.
I don't think so. Yeah, I don't think that will happen.
Now just look at the practical application. You're a buyer and you're asking, if you started asking for this, don't you think your offer wouldn't be considered? You'd be the last person they pick, even if it's above, right? So you can.
Right. If I'm a seller, why would I want to do that? Why would I
want to take money off the top and then
for an agent that's working against me,
or perceived to be working, because they try to, people say cooperating and so on. Now, these huge companies never need an MLS. They have enough buyers that come from their own company that they have an intra-company transaction that happens all the time. But one thing we're, not really mentioning, dual agency has been the hottest topic ever in real estate. You agree with that? Okay. So now there's no more dual agency if people take this approach, because now everyone's treated like a customer. So they don't owe any duty to any buyer. So to me, this renders dual agency when you ostensibly represent both sides. If you can walk that tightrope. This is not anything where a buyer comes and makes a phone call listing agent. It's not dual agency. They're a customer. You owe your duty to only one person, your client. So it's going to make it. I think dual agency be gone, because there aren't automatic.
Because most people will go directly to the listing agent. That's what you're saying. They're going to go directly to the listing agent. The listing agent's going to double end it, but continue to represent the seller and treat the buyer as a customer and the seller as a client.
Right. Now, we're giving the facts, and to some extent, we're giving a doomsday scenario. I think you're wrong. I think I'm wrong, because culturally and actually, there's a lot of equity. The older folks and people say, they know it to be the way things are done. They want someone who's going to be, at the very least, a seller might want someone on the other side who's not going to be a pain. They're two realtors. They speak the same language. They know how to get a deal done. They're going to make sure to give him a qualified buyer.
1,000 times.
They do this. They know the buyer. Let's say they make sure.
They know what to do.
Your own listing agent may not really qualify buyers as much. Maybe they're not, getting into it. They feel, listen, if this buyer doesn't work, another buyer will. So they may not care, but that's the one shot for buyer's agents. So, I mean,
I think there's a lot of opportunity for buyer agents to really show their value here, but they have to learn it. They have to relearn it, not learn it, relearn it, because the value that they had before was a little bit different. Now they have to go out there and really put their money where their mouth is, because now they have the contract. They have the contract between what their service is and their buyer. They're no longer relying on the listing agent to incorporate their fee in there.
Right. And keep in mind, we're discussing this pre
everything.
decision, and the plaintiff, I'm sorry, the defendant's efforts at appeal have not proven fruitless. And even if there was proof fruitful, there's no denial of a possible. So we're just talking from today's date, which is what, the 7th, 6th,
right?
7th? Okay.
But no matter what happens from this moment, actually from the 31st of October on, everything changes.
Yeah, I understand. But the only thing that really changed is the mandatory nature of the offer of compensation. I think in my board, there's going to be the vast majority, I think upwards of 90%, because of the way business is done. There'll be an understanding that there's value. There is value to a seller by paying a commission, especially when it's this monopoly money from 2021, 2020, right, from COVID. So it's not like they worked and scrimped and saved. This is money off the top. So they're going to, I'm telling you, it's not going to have a big effect. Practically speaking, there are instances where sellers may want to think, listen, I can pay half the commission. And there are instances when buyers, if faced in the limited number, let's say 90% commission, 10% of those deals may require agents to demonstrate their value. And they can do it, as you said. And realtors have tons of value: negotiation, repairs, pricing, working with the professionals, bankers,
I do
appraisers.
think that a large majority here will not be able to do that.
Right.
I
And
think
that's
you're
why
going to see a huge exodus, and that is a scary thing. Look, you talked about injunctive relief. That is what the court is going for. They want the system to change. They don't care if the real estate agents stay in business.
that's what the plaintiffs want and the Department of Justice wants, not the court. The court's an impartial body. But I got you. I mean, that's where this is. But I mean, there are opportunities. That there are so many buyers. There's another thing that what is it? Millennials are the greatest buying power of all time. Rumors are dying, and there's a whole. I mean, yes, there's a shortage of inventory.
But millennials also have a different perspective on how they are going to choose what they're going to purchase and what they're not. They have that instant gratification. They want to go online. They want to move fast, right? So it is a very different dynamic. They're not going to sit down and do a buyer consultation. They're going to say, send it to me. This is what I'm willing to pay you. This is how it's going to go down. And then they're going to move on.
I mean, that's the prototypical one.
Roll with that. They have to know how to handle that objection. They need to know how to get that and how to actually welcome that, because that's where it's going.
Right. And let's speak about learning. Is the board, are the respective boards going to give this training? Are the broker owners going to do something they never did? I mean, they've been, the topics that have flown around the world in the recent past: social media, lead gen, AI is a sexy new subject. It's social media. I mean, the statistics are horrendous, thinking that you're going to post on Instagram and get a client for 600,000. It's actually just not true. If you look at the NAR report of February 2020,
less than 1% of the business.
Less than 1%. So putting your stuff on social media is a 99%. And people will fight me on that constantly. But I rely on my trade organization statistics. That's all I do. I don't have any opinion on it. But I mean, there is a way, if someone is properly certified, if there are some entities that can provide this instruction in a neutral sense, if there's a way for someone to be exposed to some learning and some tactics and some strategies and utilizing methods of becoming really valuable, I think those are the people that can survive and thrive. I mean, it's.
I completely agree with you. Totally agree with you on that. Yeah. Look, I think we have to watch this very closely. I think we have to tune out all the noise that's going on social media, and we have to really rely on the facts of this case, where it's going, what's happening. Will there be an appeal? If there is an appeal, what will happen next? Because you have at least 3 other lawsuits that are coming down the pike that are already filed. This is happening. So we have to pay very close attention and just maybe talk again tomorrow, because things change from minute to minute.
Right. There's a lot to learn. It's obviously the biggest subject. Now the public knows. It's on the media. It's on CNN. the public knows, and there might be
Everyone's talking about this.
everyone's talking, because think about it. If NAR is 100 years old, basically everyone you know has gone through a transaction. Could be rental, could be purchase, could be investor, could be your friend. How many people do you know that
The
became
whole world is intrigued with real estate. They built a whole channel, HDTV, around real estate.
right? And
Everyone
Zillow,
loves real estate. So this is a very big topic. It's not just a topic for agents or lenders or title. This is a topic everyone is talking about. And everyone is looking at this and saying, can I save money? Agents are saying, how do I make money? Lenders are saying, how do I keep my referral partners in business? Everyone is looking at it from a different perspective. So again, we have to watch the facts. We have to tune out the noise. And I am looking forward to talking to you tomorrow.
yep, we'll do more.
Thanks for sharing all this today. I appreciate it.
Take care. Talk later.